none of my subpoenas had addresses, as we went on the record.
Your subpoenas didn't have addresses? Well, they were definitely yours then, wasn't they, Darrell? Because you ain't have one either. Boom. That's terrible. You set that one up for me, Darrell. I don't know what to tell you.
You only have an entity named.
Is it not true that under the Sixth Amendment I have the right to face my accuser?
Mr. Brooks, let me hear from the state.
Yes, Your Honor, I agree with the court's assessment. The subpoena does not state a person. The subpoena form specifically indicates that the person requesting the subpoena is to indicate the witness's name and address. Mr. Brooks has simply written the word State of Wisconsin plaintiff.
Sound
the
about
witness
right.
name. The State of Wisconsin is an entity. It's not a person. The State of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor.
Your Honor, on the grounds that every document that was filed in this matter stated that the State of Wisconsin was the plaintiff, which would lead me to believe that the State of Wisconsin is who's bringing the claim against my client.
Oh, he got us. He got us, Your
How
Honor.
could they not be subpoenaed to testify if they're the plaintiff?
Damn. We almost had him, Your Honor. We almost had him. But he caught us. He caught us. Oh, damn. Somebody get the key to them shackles. Get him out of here. He's so clever. He's so clever and we so stupid. You know, like, we almost had you, Darrell. We almost had you.
And under the Sixth Amendment, I have the right to face my accuser.
Yup. I'm gonna face
My
him.
accuser in this matter is the plaintiff, which is the State of Wisconsin. Attorney Opper also brought up that it didn't have an address on there. None of my subpoenas had addresses, as we went on the record, and that was stated that a lot of the...
Dang, your subpoenas didn't have addresses? Well, they were definitely yours then, wasn't they, Darrell? Because you ain't have one either. Oh, boom. That's terrible. You set that one up for me, Darrell. I don't know what to tell you. My subpoenas did not have addresses. Neither I or my subpoenas had addresses, is what I'm telling you, Judge. That's how I knew they were mine, because we didn't have addresses.
The paperwork that I have don't have a lot of the people's addresses on there, and those subpoenas were accepted. So I don't see the difference with this subpoena not being accepted for the reasons that Attorney Opper just stated.
Mr. Brooks, in relation to that subpoena, based upon my review for completeness, this court would note you have not named a person, you've named an entity, and the subpoena will be kept on file as part of the court record, but I'm not going to require the State of Wisconsin to testify in this case because they are an entity and you have not named a person.
Are they not? Or are they not the plaintiff, Your Honor?
They are the plaintiff in this case, sir.
And why are they not able to testify, being that they...
Sir, you've named an entity, not a person. People are called to the witness stand to testify.
People,
you have had an opportunity to cross-examine every single person who has been called by the state to testify in this trial. I believe that your Sixth Amendment rights have been complied with.
Not if I'm not allowed to face my accuser, Your Honor. My accuser in this matter would be the State of Wisconsin. With all due
Sir, I
respect,
believe your Sixth Amendment rights in that regard have been complied with.
I'm requesting a written judicial finding of fact and conclusion of law on this issue for the grounds that I just stated. It was seen, based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser, then how can the claim even stand? How can a claim be brought against my client if I'm not able to face the accuser?
Wait, how do you know that Darrell Brooks is your client if you don't know anybody named Darrell Brooks? You just said that was your client, but then you say You don't know nobody by that name. So how you gonna represent him if you don't even know him? I don't know anybody by the name of my client. Now, wonder you did so bad and got 1,000 years. Shit, the least you could have did was introduce yourself to your client, Darrell. I mean, for damn.
So this case is a criminal case in a court of competent jurisdiction in the state of Wisconsin,
hey, Rachel.
Waukesha County. This case was initiated initially by the filing of a criminal complaint. Then there was a preliminary hearing where probable cause was found. After that point, there was an information that was filed. And at some point, an amended complaint, perhaps even a second amended complaint, was filed as well, putting you on notice of the charges and the factual basis for those charges, along with the statutes that are alleged to have been violated. I'm not going to explain any further why you can't call the state of Wisconsin in the way that you've subpoenaed them or attempted to subpoena them for the reasons I've already stated. I understand where you might disagree with the court's ruling, but my ruling stands, and I'm not requiring the plaintiff in this case to serve that subpoena in any way for the defects I've already noted.
May I state for the record?
And I'm also not going to issue a written decision on that. The record speaks for itself.
May I state for the record, Your Honor, that I have not even seen a complaint in this matter, and the jurisdiction still has yet to be proven, which is another thing that needs to be challenged. There has not been proven that there's challenged? Subject matter jurisdiction as.
Oh my God, Darrell. Just give that one up. Move on to your next thing. You haven't proven the subject, the matter, or the jurisdiction, Your Honor. You've done all this, but you haven't proven the thing that you need to prove to get me up underneath of this here prison, okay? I'm not going without my jurisdiction, okay? Look at her. Look how he looking at her. I do often wonder if he believes, like, no, I don't. Let me stop lying. I don't believe for a second that he believes or understands anything he says. I'm actually quite positive. This is like, it's so weird though. It's like the boldness of you. You know, there's no plaintiff. If you can't bring Wisconsin in here, you got to let me go, okay? That's not my problem, Your Honor. You got to get Wisconsin in here. Look at her. Darrell, like, how was this supposed to work? But how, though? Like, if you can't get Wisconsin in here, I don't know what to tell you, Judge. You're just going to have to let me go. It is what it is. Right, Darrell? High five.
There's no verified proof of it. There's no verified proof of even a claim, especially if I'm not allowed to face my accuser. And I don't understand how you can make that judicial decision, Your Honor, when it's clear discrepancies in the paperwork of this matter.
Oh, the paperwork.
Like I said, I have yet to see jurisdiction be proven. It has not been proven. I have yet to see a complaint. I have not seen that.
The court has provided you with, I believe it was the second amended criminal complaint, along with the information that was provided to you previously and noted on the record. I've already addressed your motion to dismiss previously. I'm not going to revisit that. There's no legal basis requiring me to do that, sir. The plaintiff in this matter has presented witnesses to establish venue. And again, as I've noted previously, it's a criminal case with criminal charges, with a second amended criminal complaint detailing the factual basis upon which these charges are based. We're a notice pleading state. And along with the information, you've been made aware of all of the charges and the penalties you face and the factual basis upon which the state has brought these charges. We are in the middle of trial. Your objections are noted. We will continue today with the jury trial.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter, Your Honor?
You can ask for whatever
Your
you want. You
request
ain't gonna
is
get it.
noted for the record. I'm not an appellate court, sir.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction.
Your request is denied.
Based on what law or fact, Your Honor?
I've previously addressed the issue, sir,
So
based
you're
on
making-
law of the case.
Are you making a judicial determination?
Yes, Daryl, I'm making a judicial determination because I'm the judge who is making a determination. I'm a determining judge, okay? So yes.
That I'm not awarded my Sixth Amendment right to face my accuser?
I'm
Because
not making any such
you
determination
sovereign.
today. All right.
What law or
I'm
fact?
going to turn to the district attorney's office. Do you have a witness available?
Yes, we're ready to proceed, Your Honor.
All right, our jurors here. All right, the jurors will be brought out, sir.
Your Honor, with all due respect for the record, you're avoiding my questions.
Mr. Brooks, I've addressed the issues that need to be addressed this morning. I've also addressed the same issues probably every day we've been in court. I know you may be dissatisfied with the response that I'm providing to you, but my responses stand.
It's not a
Hey, Harley.
satisfaction, Your Honor. It's a lack of understanding, which I don't have. I don't even understand that.
Well, if you don't have a lack of understanding, that means you understand, Daryl. That was a double negative you just did. You know what a double negative is, Daryl? Let me tell you. Nope, I ain't gonna tell you because I want you to keep saying stupid shit. Because it's funnier that way. If you get educated, it will be less hilarious. So no, I'm not gonna tell you what a double negative is. I'm gonna keep letting you use them, and then I'm gonna mock you for it. Cause fun.